Hey everybody, how are you? Kelly Henderson here with another bit of advice for you or experience to share with you. Um, Today we're talking about arrest. What is going on once someone has been arrested and you're trying to get them out of jail, you're trying to figure out how to get information on what's happened? Well, you can call the county jail that of the county that arrested them. Everybody, no matter if it's a city police department or the county sheriff or the Georgia State Patrol, they will end up at the county jail in the county in which they were arrested. And the county jail should have a booking area. You can call the county sheriff who runs all the county jails in the state of Georgia. Call the sheriff's office, ask for booking. A lot of times it's the main line that you get goes straight to booking because they get the most traffic out of all the sheriff's hotlines. But they will transfer you to booking if you're not already with someone in the booking area. They can look up the name, let you know what the charges are currently, let you know if they're there, also let you know if they have a bond. If they were arrested for misdemeanors, most likely they will be automatically set bonds when they get to the jail, and you can go ahead and bond them out. Call a bondsman, or show up with cash. Ask the person at booking what you need. If you want to do a property bond or a cash bond, or if you want to call a bondsman, then you'll need to call a bondsman that's licensed in that particular county. If they're charged with a felony, certain felonies in certain counties may also already have a sheet that assigns specific bonds for specific charges. If not, they will need to wait until the first appearance in front of a magistrate court judge who will assign a bond or not. If they don't assign a bond, that means they've got some more serious types of felonies that they're looking at. The first appearance may be pretty quickly. It's usually within a day or two, and they will get a bond. Then you can hire an attorney. An attorney can go be with them, be present at the first appearance, and ask for a bond. Oftentimes, it's not important to have the attorney present at the first appearance. Although if the person has a really important job that they will definitely lose if they stay in jail for any period of time, you may want to try to take that step. You'll have to move quickly, getting in touch with attorneys that are going to be able to get hired and then appear at the first appearance and make their case for a bond. If you don't get a bond at first appearance, the next chance is the preliminary hearing, also in front of the magistrate court judge. If someone is in jail without a bond, or if they've been in jail with a bond but they've been unable to make bond, then they will have an opportunity for a preliminary hearing. It is a probable cause hearing. The attorney, hopefully you can get an attorney hired in time for somebody who's in this situation where they've been sitting in jail for, it'll be usually at least a week or two before they get in front of the magistrate court judge for a preliminary hearing. Typically, they'll also be assigned a public defender if a private attorney has not been retained, although that may take a little bit longer to do. As far as the private or the public defender's office having personnel available to handle the first appearances, the preliminary hearings. The public defender's office will not participate in the first appearance. They will participate in preliminary hearings, but they operate a little differently. A private attorney may have an ability to get the defendant on a preliminary hearing calendar before the public defender's office would. Typically, because the public defender's office just has so many clients, they're so backed up, there's only so many cases that can go on each preliminary hearing calendar that it takes a while to whittle through those cases. And so the public defender's cases may get stacked into calendars that are further away, just because they have so many clients. But at the preliminary hearing, you can ask for a bond again. Oftentimes, you exchange having the preliminary hearing for a bond instead of using the court's time on the hearing to see if there's probable cause to continue to keep the person under arrest for the warrants that they've been charged with. You say, Judge, well, we would just rather you set a bond in this case and we'll waive the hearing. Each county does things differently. So this doesn't apply in a cookie cutter fashion to every county in the state of Georgia. But typically, you can negotiate with the district attorney's office and get a bond in lieu of the hearing, or you can ask the judge to set a bond in lieu of the hearing, or you can have the hearing. Maybe a bond gets set, maybe a bond doesn't get set based on what comes out during the hearing. The judge may actually dismiss the warrants if there's no probable cause to continue to keep the person under arrest. And again, an attorney for the defendant can do an investigation, maybe find something that demonstrates an alibi or some other defense, mistaken identity, something like that. Someone lied, and now that person who lied is willing to recant that lie. That is what initially caused the police to arrest the defendant in the first place. Any number of things can happen. I will say it's rare for a case to be dismissed at the preliminary hearing. It's always worth taking a shot. Can't hurt unless you need to exchange. You would rather exchange your shot at the preliminary hearing for a dismissal for a bond. And so those are kind of the first steps of what is going to happen when someone's been arrested and they've been put in jail. Those are the things you can look out for. Hopefully they get a bond immediately. If not, they'll hopefully get a bond at that first appearance in front of the magistrate judge. If not, hopefully there's an opportunity to get a bond or have the case dismissed at the preliminary hearing.